to say a special congratulations to everybody here, including the presenters as well as the people asking questions. And I want to say the people that are not here are very unfortunate because they've missed a great event.
Yeah. Before you make any report, you have to make a citation of a work done or a report by any reputable organization.
Objective should not simply be to have fewer MDAs, but to have better MDAs. Institutions that are legally justified, financially sustainable, ethically governed, professionally managed, and accountable to Nigerians.
There should be need for MDAs to embrace digitization. There should be statutory penalties for non-compliances of any MDAs.
Thank you very much.
I'd like to take the next question. Frameworks governing the creation, restructuring, and dissolution of federal MDAs account for and protect institutional memory and public records continuity during administrative transitions. This is a very interesting question. And it's so funny because this question actually takes us to the Heritage Preservation Institutional Memory Units. Shall we invite them up to tell us more about this?
In answering this question, to what extent statutory framework governing creation, restructuring, and dissolution of federal ministries, departments, accurate, organized information for future references, accountability, and also for decision making. Now, the importance of record keeping cannot be overemphasized. For any MDAs to have good, proper record keeping and continuity during the administrative transition, there must be a need for decision making. This will now take us to the National Archive Act 2004. This act serves as a foundation, a legal foundation for preserving, managing public records for present and future purposes. Now, the act mandated that record transfer protocol must be adhered to. Record transfer protocol must be adhered to with the purpose of preserving the records, managing the records, and accountability, and also easy access to information. However, some MDAs fail to transit in administrative functions for record keeping due to poor record keeping and also analog or paper-based archival system. And when we say paper-based archival system, it is an act of keeping files. Like, for example, I went to get a birth certificate for somebody. And when I got there, the people in charge said that I should go to a department. On getting to that department, they asked me, what year am I looking for? I gave them the year. It took me almost the whole day for them to sort out the record. So when we say paper-based record, this can also hamper a federal, in public record continuity during administrative transition of federal ministries, departments, and agencies. The Act also mandated public record should be scheduled, appraised, and transferred to the National Archive. However, some MDAs failed to hand over public records for continuity during administrative transitions due to weak enforcement of the existing archival law. No sanction to any DGs, PAMSEC, directors who failed to hand over to the new administrative. So with this, we can now see that there is an issue if public records does not have continuity during administrative transition. With this, we come up with some recommendations that there should be need for modernizing or strengthening the National Archive Act. And also that there should be need for MDAs to embrace digitization. When we say digitization, it can be also called digital preservation. That analog way of getting records will no longer be needed. I think some time ago, my unit, we went to submit an engagement letter to one of the ministries. That was about 2 months back. And we went for follow-up of the letter. And when we got there, they said the letter is already in the office of the DG, that we should come back another time. After a while, we went back again. They said the letter has been sent from the DG to another department. To cut the long story short, we were asked to write another letter again. Why? Because there was no proper tracking of records. So you can see the need for public record continuity during administrative transition of federal ministries, departments, and agencies. Now, and also, another recommendation is that there should be statutory penalties for non-compliances of any MDAs. There should be statutory penalties for non-compliances of any MDAs, so that any ministries or departments who fails to transfer their records to the National Archive Act, they should be able to be held accountable. So with this, I think I should be able to have answered this question: to what extent do constitutional and statutory framework governing the creation and restructuring and dissolution of federal ministries account and to protect institutional memory for public records continuity? Thank you very much.
Because that's exactly the core mandate of the library. That's what we do here. That is why the library was established. I'd say the heritage preservation and institutional memory is a very core unit in this library. The library, if you look at the question, the creation, restructuring, and dissolution of federal, I don't know if you guys are aware, but some of the library staff of the National Assembly got absorbed into NAUTAF. So that was, without a doubt, this particular question explains NAUTAF or public records. You see how he complained about not being able to track records and everything. That is why we are here. It's one of our core mandates: archivement, engagement with the stakeholders. So shall we give them a round of applause one more time for that lovely answer to that question? So we make progress. Rights and ethical principles be strengthened within the legal framework governing the creation and restructuring of MDAs in Nigeria. I feel like things that are going. Shall we invite the Parliamentary and Policy and Ethics units to take this question? Thank you very much.
morning, my ebullient researchers. Ebullient means to be excited, to be highly spirited, to be enthusiastic. Are we excited this morning? Yes. Please, can we all rise? Inhale and exhale. One more time. Inhale and exhale. Thank you so much. Please have a seat. My name is Fatima Abdullahi Ouna, and I'm representing the Parliamentary Policy and Ethics Unit. The question asked today is, how can ministries, departments, and agencies are the machinery through which government implements policies and also deliver public services? We all know that. Government may create or merge or restructure MDAs to improve efficiency, to eliminate duplication and reduce the cost of governance. However, when it's poorly managed or poorly restructured, it can lead to waste of public resources, it can lead to conflict of interest, it can also lead to weak accountability, and so much more. Therefore, parliamentary oversight and ethical principles are essential to ensure that MDA reforms serve the public interest. We have some major legal framework. Some of the major legal framework in this aspect include the 1999 Constitution as amended, which provides the foundation for the organization of government parastatals or institutions. We have the Fiscal Responsibility Act 2007, which promotes prudent management of public finances. The act is also important and relevant because every new MDA creates financial obligations. So this act is also very important. We have the Public Procurement Act 2007. The act regulates public procurement and provides mechanisms for procurement oversight. And it is relevant for restructuring contracts and procurement, among others. So, why parliamentary oversight matters? Parliamentary oversight matters because the Parliament will have to ask some necessary questions before these MDAs will be either reformed, restructured, or abolished in any, as it may be, as the case may be. So the questions that are very necessary to be asked include, why does the agency need to be created? Does the agency perform the same function as other existing agencies or not? How much is the cost? Cost is very important also in this aspect because in whatever we do, resources matter. So we need to know the cost. The parliamentary need to know the cost. Is it beneficial to Nigerians or not? Is the agency achieving its statutory objectives? That's for existing agencies. Are they delivering their mandates or not? And also, should an existing agency be merged, restructured, or abolished? So, we have some of the major challenges that these creating agencies that already exist may cause if in case an existing agency is being duplicated. So this, some of the major challenges are duplication of functions. Several MDAs may perform similar or overlapping functions, and this increases administrative costs and creates confusion. The second major challenge is we have political patronage. in a situation whereby institutions can sometimes create additional positions for appointment, thereby undermining the public interest, justifying why that agency was created. We have executive dominance. The executive has significant control over public administration, which may have a strong legislative scrutiny, particularly in this case. Then, strengthening parliamentary oversight, I'll propose 5 measures. Number 1 is, before creating an MDA, the government should provide Parliament with the following. What are the problems they intend to solve? Why exactly does that agency need to be created? Are there existing agencies performing similar functions? What are the proposed mandates for creating that agency? What are the cost implications, like I mentioned earlier? The staffing requirements, because definitely when a new agency is created, there will be need for employment of new staff. The expected benefits, the performance indicators, and lastly, alternative options. Are there other options, or it has to be created? Then there should be a periodic review of the MDAs, existing MDAs. This will enable the agencies, the Parliament, to know if the agency should continue, if it should be reformed, downsized, or merged, or even abolished completely. Then we have a stronger follow-up. Parliamentary recommendations should be tracked until corrective actions are taken. And lastly, strengthening ethical principles. Ethics should be incorporated into the MDA structuring process, and the key principles include integrity. Decisions must be honest, there should be transparency, there should be accountability, there should be impartiality. All these principles need to be adhered to. My major recommendations are: government should conduct impact assessment before creating or restructuring MDAs to establish their necessity and cost. Parliamentary committees should be strengthened to provide effective oversight. MDAs should undergo periodic performance reviews to determine whether they should continue, merge, or the agencies should be restructured. Budget should be linked to measurable performance and value for money. Transparency and stakeholder participation should be improved. And lastly, Parliament should ensure that its recommendations are properly followed up and implemented. And in conclusion, the objective should not simply be to have fewer MDAs, but to have better MDAs. Institutions that are legally justified, financially sustainable, ethically governed, professionally managed, and accountable to Nigerians. Parliamentary oversight must therefore go beyond improving the creation of MDAs. It should begin at the point of establishment, continue throughout their operations, and ultimately determine whether they remain relevant, effective, and capable of delivering value to the public. Thank you very much.
The way she engaged us all so that we don't fall asleep during the presentation. I know some of us have questions, and so the next question is, how adequate are the energies such as genomic and precision medicine in Nigeria? Shall we invite the Science, Innovation and Technology Transformation Unit to answer this? Thank you.
For that. Good morning, our HOD. Good morning, everyone. My name is Jamila Muhammad Ode from Science Innovation. Medical field that uses genetic information or genetic makeup of an individual to give clinical care. While precision medicine uses the individual unique genes, lifestyle, environmental factor to give clinical care and prevention. So this question talks about the adequacy of establishing institutions that regulate emerging health technologies such as genomic and precision medicine. If I was asked to give a yes or no as an answer, I will boldly say no. Why? Because the framework is partial and fragmented. It is not comprehensive when it comes to emerging health technologies. So looking at the constitutional basis, the Constitution of the Federal Republic of Nigeria 1999, as amended, states that public health sits on the concurrent legislative lists, which gives the states and the federal government the power to enact any health-related matters. The Section 17(3)(d) of the Constitution obliges that states provide health facilities to the general public. So this is aspirational and is not enforceable, if you look at it well, and also no constitutional recognition when it comes to genomic medicine, genetic testing, or genome editing. So Nigeria has several statutory institutions which support the regulation of emerging health technologies. These institutions are, we have the National Health Act 2014, which established the general framework on health, general health framework, but is silent on genomics. Then we have the National Center for Disease Control and Protection Act 2018. This act is strong on disease surveillance, but not clinical genomics. Then we have the NAFDAC, that's the National Agency for Food and Drug Administration and Control Act 2004. This regulates drug, biological products, but not gene therapies or pharmacogenomics specifically. These regulate laboratory practice and accreditation, but no specific standards for genomic laboratories in Nigeria. Then we have the Nigerian Data Protection Act 2023. It protects sensitive data generally, but no specific genomic data or biobanks governance. Then we have the National Biotechnology Research and Development Agency Act 2022. This focuses only on research and then research on biotechnologies, but there's nothing like clinical regulations on genomic. Then we have the National Health Insurance Authority Act 2022. It ensures that all Nigerian citizens and legal residents have health provisions, but the health provisions do not cover all health aspects. Not to talk of health, emerging health technologies. So Nigeria already has relevant, strong existing bodies, such as the capable of supporting genomic and precision medicine governance, such as the Federal Ministry of Health, the National Center for Disease Control and Protection, the National Agency for Food and Drugs Administration and Control. We have the Medical Lab Science Center for Nigeria. We have the National Biotechnology Research and Development Agency. Then we have the National Institution for Medical Research, we have the National Health Research Ethics Committee, we have the National Data Protection Commission. These are solid base that genomic and precision medicine can be built on. But despite this, Nigeria still have some lapses. Some of these gaps are no dedicated Genomic and Precision Medicine Act or regulatory authority, no standards for genetic testing, counseling, biobanks, or gene editing. We have weak interagency coordination, then gaps in informed consent, AI oversight in genomics, and cross-border data sharing. Based on the gaps we have, I provided some recommendations. Nigeria needs to enact a dedicated Genomic and Precision Medicine Act, establish National Genomic and Precision Medicine Regulatory Authority, harmonize existing laws, strengthen ethical oversight, and also strengthen National Health Research Ethics Committee. Build a genomic data governance framework, improve interagency coordination, capacity building, financing, infrastructure, anti-genetic discrimination safeguards need to be provided, then legislative oversight, international alignment. Today, I would like to leave you with some of my suggested discussion angles. One, give priority ranking among all recommendations. Whether a new or empowering an existing body is more feasible. Funding is a political will. Balancing innovation with ethical privacy safeguards. Thank you.
For instance, in education, the National University Commission, National Board for Technical Education, and National Commission for Colleges of Education all regulate different tiers of tertiary education, but sometimes issues conflicting directives to institutions, causing confusion among the university, polytechnics, and colleges of education. Secondly, Universal Basic Education, Teachers Registration Council of Nigeria, National Teachers Institute, and National Commission for Colleges of Education all have roles in teachers training and professional development, which can lead to dispute over program ownership, accreditations, and standards. The coexistence of JAM, WAEC, NECO as examination bodies sometimes results in overlapping responsibilities, duplicative testing processes, and confusion for students and educational institutions. These examples from the education sector underscore why physical prudence and clearer governance structures are critical, as emphasized by the Oronsai report. Now, with this, we have some policy recommendations. One, enforce legal and constitutional due process. That is, it requires that all new education agencies undergo rigorous legal and need assessments, ensuring mandates are clear and not duplicative of existing agencies. Two, mandate physical impact assessment, make detailed cost benefits and physical impact analysis mandatory before establishing new agencies to prevent rising wage bills, and administrative overhead. Thirdly, strengthen oversight mechanisms. Empower the National Assembly oversight bodies to monitor the creation and operation of education agencies, preventing arbitrary or politically motivated proliferation. Institutionalize regular audits. Conduct periodic review of the education agency's mandate and performance to identify and address overlapping functions, redundancies, and inefficiency. Lastly, implement the Oronsaye report recommendations for fast-tracking legislative and executive actions to match, streamline, or reform redundant education agencies, especially where roles overlap, to ensure effective service delivery and optimal resource use.
That was a lovely presentation from the Public Health, Education, Youth and Social Services unit. If you guys can recall to the first presentation by the GCPA unit, they also spoke about the Oronsaye reports. That's for things like that to be adapted as recommendations. We'll go to the next question. Apply to the President's executive powers in creating government institutions that perform security functions. I think this is a very interesting question because we've left the legislative and we're looking at it from the executive perspective. Shall we welcome the National Security, Architecture and Governance Unit to shed more light on this? Thank you very much.
Good morning, able colleague. Hope you are blessed this morning. Institutional limit should apply to the President's executive power in creating government institutions that perform security functions. We're talking about separation of power here. We have the executive, the legislature, and the judiciary. And bring us to the question, the answer is, in the simple terms, the President cannot create any security institution simply because he has executive power. His power must stay within the limit of the Constitution and existing law. Constitutional authority, any new security body must have clear legal basis and must not conflict with the Constitution. Then we'll talk about the constitutional provision on the President's executive power. Under the 1999 Constitution of Nigeria, as amended, the President exercises executive power under Section 5 and Section 130. This power allows presidents to direct and coordinate the government institutions, including security agencies established by the Constitution or by an act of the National Assembly. So I want to talk about the creation of state police. We can all say that the President doesn't have the power to create. It must go through the National Assembly, then to the state. So the President does not have, like we're talking about Section 1, Section 5 gives the executive power. The Section 5 gives executive power. Why the Constitution itself places limits on how the power can be exercised. And we're talking about the statutory instrument and executive power in creating new institutions. Statutory instruments such as acts of the National Assembly provide the legal basis for establishing government institutions and defining their power and function. The President allow him to implement this law and, where legally permitted, establish administrative structure needed for effective governance. In summary, the legislature provides the legal authority while the president exercises executive power to implement and administer the institution. Physical implication of expanding government structure. Expanding the government structure can increase public expenditure because new institutions regard funding and salary, offices, equipment, and operation. It may also increase the government's recurrent costs and administrative burden. However, if properly planned, expansion can improve service delivery, security, and efficiency. In a nutshell, government expansion can be based on clear needs and available resources to avoid unnecessary financial pressure on public funds. Governance challenges of overlapping mandates and duplication. Overlapping mandates and duplication of function can lead to confusion, conflict among government agencies, waste of resources, and poor accountability. They may also cause delay in decision-making and reduce effectiveness of public service. Our recommendation, after due research of this question, national security, architecture, governance came up with a recommendable policy, very recommendable, which I will urge the National Assembly to look into this recommendation. And the creation of state police, we can all say that the government, the president doesn't have the executive power to create. It must go through the constitution by amending the section, like section 214, talk about the creation. We're talking about the police force. There shall be a force called police force. But subsection 3 talk about there shall not be any other police force in the federation or any part of the country. But now we're talking about the expression of state police. That is why it's going through. I think it has passed through the Senate and the Rep. Now I think there is a committee level now. That's why it's not fully functional, the state police. So our recommendation is as follows. Following the constitutional limits, the president should act within the power granted by the constitution and avoid creating statutory security agency without legislative approval. It must pass through the National Assembly and State Assembly. That is why the state police must go through the state, at least 2/3 of the state, before it can be passed into law. The president doesn't have the power to just wake up one morning and create agencies such as the security. 2, require legislative oversight. New security institutions should generally be established through an act of the National Assembly, which I just said now. It must pass through the act, but you must amend that clause that says there shall be no other police force. That act must be amended before the president can create any security agency. Conduct needs and cost assessment. Before creating an institution, government should assess its necessity, function, and financial implication. To avoid duplication, clearly define mandates to prevent overlap with existing security agency. Strengthen accountability. New institutions should be subject to appropriate legislative, financial, and judicial oversight. In a nutshell, in summary, the process should balance the president's needs to respond quickly to security challenges with constitutional check, legislative approval, financial discipline, and clear institutional responsibility. Thank you very much.
National Security Architecture Governance Unit. I'd like to welcome a very special guest that's just joining us now, the Executive Secretary of the National Assembly Library Trust Fund. Shall we give him a round of applause? Thank you, sir. I'd also like to observe protocol by also welcoming the Directorate of Research and Information Services of the National Assembly, ably represented by Madam Bukola Akintule, the Assistant Director. Thank you very much. As you guys can see from the presentation by the NSAG units, it's a unit that really intrigues me because he went straight for the Commander-in-Chief of the Armed Forces to speak about how the federal government's agricultural renewed hope agenda is designed to improve food security as economy. However, achieving these goals depends not only on sound policies, but also on the institutions responsible for our existing ministries, departments, and agencies, MDAs, adequately structured, coordinated, and empowered to effectively environment and climate change units to shed more light on this question. Thank you.
To successful policy implementation is the fragmentation of institutional responsibilities. Several agencies perform related or overlapping functions, resulting in duplication of efforts, weak coordination, inefficient use of public resources, and delays in program implementation. These challenges are often compounded by inadequate funding, limited technical and human capacity, weak monitoring and evaluation systems, and inefficient accountability mechanisms. Rather than expanding the bureaucracy through establishment of new MDAs, governments should prioritize institutional reforms that strengthen the capacity of existing agencies. Such reforms should include clearly defining institutional mandates, eliminating overlapping responsibilities, improving collaboration among relevant ministries and agencies, aligning budgets with policy priorities, adopting digital technologies to improve service delivery, and strengthening performance monitoring and accountability framework. These measures would enhance efficiency while ensuring better value for public expenditure. The National Assembly also has an important role to play in ensuring the success of the Agricultural Renewed Hope agenda. How? Beyond approving budgets, the legislature should exercise effective oversight by monitoring program implementation, evaluating institutional performance, ensuring prudent utilization of public resources, and holding implementing agencies accountable for measurable outcomes. Oversight should focus on increasing agricultural productivity, improving food security, promoting climate-smart agriculture, protecting the environment, and enhancing rural livelihoods. Where evidence reveals genuine institutional gaps that cannot be addressed through reforms or restructuring, legislative action may be necessary to establish new institutions. However, such decisions should be based on rigorous evidence rather than administrative convenience. Strengthening existing institutions before creating new ones will help reduce duplication of functions, promote fiscal discipline, improve governance, and accelerate the implementation of the Agricultural Renewed Hope agenda. So what we would recommend, that's the policy recommendation. The National Assembly should adopt a strengthen before creating approach to institutional reform. Before any proposal to establish a new ministry, department, or agency in the agriculture, food security, environment, or climate change sectors is considered, we would like to say that 1, a comprehensive review of the mandates, capacities, and performance of existing institutions should be looked into. A legal assessment to identify overlaps or gaps in statutory responsibilities. A fiscal impact assessment and cost-benefit analysis to determine long-term sustainability. evidence demonstrating that existing agencies cannot effectively discharge the proposed functions. Lastly, clearly defined performance indicators, accountability mechanisms, and monitoring frameworks for any new institutions. So now, adopting this approach will strengthen governance, improve institutional efficiency, enhance performance, improve public resources, and position existing institutions to effectively implement the federal government's agricultural renewed hope agenda. Ultimately, stronger and better coordinated institutions not simply more institutions will be essential to achieving sustainable food security, agricultural transformation, environmental protection, climate resilience, and inclusive economic growth in Nigeria. Thank you for
Well, not the least, what legal safeguards should be put to prevent the executive from creating institutions whose functions substantially overlap with those of existing statutory bodies? To shed more light on this question. Thank you.
Good afternoon, Master. Good afternoon, colleagues. Representing the Legal, Regulatory and Legislative Practice Unit of the Research Department, explaining what the Legal, Regulatory and Legislative Practice reviewed, and how the legal and regulatory systems can be improved to support effective governance. So, moving to the question, it says, what legal safeguards should be put to prevent the executive from creating institutions whose functions substantially overlap with those of existing statutory bodies? Any institution to the National Assembly, it should be required to demonstrate that the proposed functions are not already assigned to an existing MDA, that there is a genuine institutional gap existing for the creation of the new MDA, that the existing MDA cannot responsibly perform the proposed functions, and that creating a new institution will provide a better solution than restructuring an existing one. This should be like a mandatory legal and institutional impact assessment for creation of any institution, rather than just an administrative exercise. Secondly, there should be a prior legislative approval for statutory bodies, where the proposed institution requires statutory powers, legal personality, regulatory authority, public funding, or powers affecting the citizens. Its establishment should be subject to an act of the National Assembly, rather than by simply through an executive directory, like my colleague Comrade said. The legislation should clearly define its mandates, powers, functions, relationship with the existing MDAs, funding, accountability mechanisms, and also oversight arrangements. Thirdly, there should be a mandatory institutional impact statement. Every bill that is seeking to establish a new MDA should also come with an institutional impact statement, asking questions like, why is the institution necessary? What existing institutions operate in the same sector as the proposed institution? What functions will they perform? Is there any overlap? What will the institution cost the government? Why can't an existing MDA, like an already existing MDA, perform the functions of the proposed institution and or the proposed MDA? And what will happen to the institution if its objectives are not achieved? These are questions that should be asked and should be attached to every bill that seeks to establish a new MDA by the executive or through the National Assembly. This will give the legislators evidence before approving such institution. Then fourthly, there should be clear statutory boundaries. Where a new institution is justified, its enabling legislation should contain precise jurisdictional boundaries. For example, instead of two regulators having broadly similar powers, where two regulators having broadly similar powers, legislation should expressly state who regulates what, who coordinates, who investigates, who enforces, and who supervises a particular area of that MDA. Fifth, there should be a periodic legislative review. This is where duplication of an MDA powers is established. Parliament should have the opportunity to amend, consolidate, merge, transfer functions, or repeal the enabling legislation via a periodic legislation review. This will determine whether they remain necessary or whether the duplication is necessary or not. Then, lastly, there should be a stronger parliamentary oversight in the sense that the provisions of Section 88 and 89 of the 1999 Constitution, which gives the National Assembly powers to conduct oversight and investigative exercises concerning administration of laws and the conduct of affairs of persons, authorities, ministries, or government departments. These powers should be exercised to help the Parliament identify where duplication is necessary and determine whether existing institutions are performing their statutory mandates effectively or not. Yeah, that's my answer to the question, what legal safeguards should be put to prevent the executive from creating institutions whose functions substantially overlap with those of existing statutory bodies. Thank you.
Had presentations from various units bordering around different thematic areas and the issues that plague those thematic areas. Research has gone into this question to give us an in-depth insight into this process as well. So I'd like to give room for questions. Anyone that has questions concerning the presentations.
Firstly, thanks for this insightful and impeccable presentation. On slide 7, you mentioned concurrent and exclusively. Please, could you shed more light on it? Thank you.
Constitution of the Federal Republic of Nigeria. Exclusive list is a list that provides the item or that mention the items that only National Assembly has power to legislate on it. While the concurrent legislative list is the list contained in the second schedule of the Constitution. Is it part A, part 1, or part 2? I think it's part 2 of the second schedule of the Constitution of the Federal Republic of Nigeria that give both National Assembly and the State House of Assembly to legislate on such items listed or provided by that particular part of the. That is both state and federal and state, National Assembly and State House of Assembly has the power to legislate on that. That is why they call it concurrent. Yes, one exclusive is only for the National Assembly. For example, health matter, education, all state government and federal government has power to legislate on that. One is like immigration, like banking regulations, all those one is limited to National Assembly. So residual is a matter that is not mentioned in that constitution. Residual is like remaining matters that is not mentioned by the constitution. So while the constitution is silent, the presumption is the State House Assembly has power to legislate on that residual matters.
Thank you very much.
Among all the things said here, I got captured with the overlap. So I want to speak on that. Before I ask my question, I want to give a brief illustration. I believe in reality. I'm a realist. So I'm talking about what is happening in our society today in Nigeria. Let me use the vehicle license or particulars, for instance. Today, the Nigerian police check vehicles particulars, road safety check vehicle particulars, VIO check vehicle particulars. In fact, in some rural areas, the military look around and they will ask you your vehicle particulars. And another example is the cybercrime. In police, there's a department in police, the cybercrime unit. Civil defense, there is cybercrime. ICPC, there is cybercrime. ELCC, there is cybercrime. In fact, if you go to the Army, Navy, you will still see cybercrime. Things like this, to me, is causing confusion, like they said. There's a time it will get, people will revolt, because when you are not trained for a specific skill and you are being asked to check it, you create confusion. So my question is this to the national security. Is there any law against this overlap? That is one. Number two, when an agency carries out functions that is not in their mandate, can that agency be sued by an individual for going outside their mandate? Just like recently in the budget, you see a health agency, you see the road construction in their budget. You start wondering. So I want to know, can an agency be sued for carrying out a function that is not under their or in their mandate? If yes, is there any example of such? Thank you.
Okay, I think Mr. Goldcliff can just...
Provision of the Constitution of the Federal Republic of Nigeria already expatiated on that. It provides that the legislative power is based on the legislatures, which is based to the legislatures. So the law that are going to make, or that they are making, is for the peace, good governance of the Nigeria. Do you understand? So, in other hand, the security agency that you say, all those security agencies that you mentioned, they have a cybercrime department that they are handling all the cyber crimes issues. So I think the Establishment Act of that particular security force already provide that, already vested them that mandate. Do you understand? To take over to manage any reported cyber crimes. Do you understand? So generally they are not out of their mandate. They are complying with the provision of their Establishment Act. So there is no duplicity.
My question is, I said, can an agency be sued for going outside their mandate? If yes, is that example of such?
My learned senior colleague already elaborated on that. She explained on the doctrine, he already explained the doctrine of Trabaris. So while the established agency acts outside the mandate of the Establishment Act, its action is not unbudged, it's on Trabaris, it's out of the law. So you can institute a legal action against that organization or commission, as the case may be.
That mandate thing. Typically, when the mandate of a public agency is being established, it stipulates the specific areas of concern or activity. But usually there's also what, I don't know what the lawyers call it, some kind of omnibus clause at the bottom of the legislation that basically says anything pertaining to their area of mandate. So, does that kind of provide them some immunity from that kind of litigation when you look at it from that perspective? Because when it gives you like a gathering clause that says any other activities within their area of, I don't know whether, like you just mentioned, road construction or something like that, can it hide under that clause or that provision?
Okay, basically, by virtue of Section 10 of the Constitution of the Federal Republic of Nigeria, and by virtue of the provision, by virtue of Section 4 of the Constitution of the Federal Republic of Nigeria that empowers National Assembly to enact law, the Section 58 of the Constitution of the Federal Republic of Nigeria said that power should be exercised by way of bill. So when we are looking at the way the bill is designed, the part of the bill, there is preliminary provision, substantive provision, and also miscellaneous provision, and the final provision. So also the substantive provision is make provision for that the legal personality or the corporate personality of the organization, that anything that is going outside law, that is any conduct by that established agency that is going outside law is ultra vires. So the person has the right to institute legal action. Or where there is overlapping, for example, there is this issue of CBN and also Security Exchange Commission over cryptocurrency. They were fighting on who get that mandate to regulate that cryptocurrency issues. So at the end of the day, they went to the court, and the court declared that it's a Security Exchange Commission that has, because it's a digital asset. While the CBN Central Bank of Nigeria, their own has to do with the monetary regulation. So that is that. So that is a personality that the organization has the right to sue and be sued. So that is that. Thank you.
I got me confused from what I know. You said you want to pass a bill from the reps, it goes to the Senate, and from Senate, it goes to a committee or so. What I know before you said this was that if it comes from the reps and is sent to the Senate and is different than Senate receives what is different, if what reps send to Senate is different from what Senate sends to rep, that is when they will now set up a joint reconciliation committee to harmonize it. That was what I understood before, but in your presentation I got it misunderstood. That's why I want you to say clarification.
So after successful deliberation of the legislative process, going through first reading, second reading, committee state, third reading, so also in the Senate. So at the end of the day, they will set up and when they find out that there is discrepancy, there is differences in the bills, so they will set up the conference committee to come and harmonize the differences before forwarded to the president for presidential assent. So that's that. I said it is coming vertical and horizontal. Vertical, it means why it's presented in only one house, for example, in the House of Representatives. After the successful deliberative, after it passed the legislative process, so they forward it to the Senate to look at it and also follow the same legislative process. After that, they forwarded it to the House, so to the President for the presidential assent. So while the bill submitted simultaneously, all the legislative process is conducting simultaneously. That is both Senate and the House. At the end of the day, they will set conference committee and harmonize the differences. That is all. But there is exception for the Appropriation Act is only initiated in the House. After the House deliberates on it, they will submit to the Senate. So this is the clarification.
Thank you very much, tertiary institution. I don't think they should be merged, because for the WAEC covers West Africa. Okay, so it's not just for Nigeria. You can use WAEC for some other countries in West Africa. NECO is basically Nigeria, so it's quite different. For the JAMB is for an entrance into a university. So you can choose to take your WAEC and your NECO and choose not to go to university. You don't need to take your JAMB. So I think there are different options. And for what it's worth, the idea of having these several scrutinies or several examinations when you're in SS3 is to show the thoroughness in education. Like, you pass through the secondary education, you need to go through this thorough test to be able to say, okay, yes, it certifies you to either enter a tertiary institution or not. So I feel that they should be separated. If you say maybe the Ministry of Education can handle 3 of them, there might be similarities in the questioning, so it might not give you that thoroughness that it demands. Thank you very much.
After which there can be a follow-up in the National Assembly to create the Establishing Act. But for agencies are created by an Establishment Act, and it is within the purview of the legislature. So if the executive goes ahead to create an agency, then they have gone outside of their boundaries, and that is ultra-vires the Constitution. So the agencies are created by
the President himself, and this power is conferred on him by Section 147 of the Constitution, of 1999 Constitution, as amended, where he can create a ministry, but the primary function of making laws, establishing ministries, and things of the sort are done by the legislature, and that's the National Assembly, both the House and the Senate. Thank you.
Continued and broader engagement with them. Like I said, it's not just for the management of the department. We want all their staff to join us in this thing. And they can also present papers at this, because the essence of this event is rubbing of minds. It's like going to a mental gym to go and practice exercise and develop your skills. So you are very welcome. Secondly, I want to say I'm indeed, walking on a cloud with respect to how this event has gone. I mean, it's not often that you conceive something and you see it, blossoming into what you dreamt about. I want to say a special congratulations to everybody here, including the presenters as well as the people asking questions. And I want to say the people that are not here are very unfortunate because they've missed a great event. So, but we'll forgive them. So we'll try and put together our conversations and try to share it with everybody that is interested. What you guys are doing is essentially what is done all over the world. All these huge events and things like that. This is what they do. They bring issues up from different perspectives, discuss it, and see how the specific issue affects their own area of interest. So when you go to an IPU event, or you go to the merger of some agencies under the petroleum industry. So that report, though some of the recommendations, when I went into the recommendation part, the presenter was saying that that report, some of the recommendations are outdated, some have been done, and in the recommendation part, you are supposed to look at areas and be specific about areas that you felt should be implemented. Then I look at under your recommendations, national security reports. The presentation for national security reports, when the presenter was making the reports, I didn't see any area where he made reference to any report from any reportable organization, either from the MDAs, Nigeria Bureau of Statistics, or any research work that was done to support certain findings. In making presentations, you don't make a general report. Before you make any report, you have to make a citation of a work done or a report by any reportable organization. And when they are talking about creation of agencies
overlapping and what have you. The problems we have observed we have sometimes is the conduct of those in offices. If you look at the security agencies are created in the spirit of working for the Nigerian people. Now, where we have issues, it's not like they are the act that establishes them were not correctly spelled. The problem we have is some of these agencies want to rush to take glory for certain incidences. Now, clearly spelled out, any organization, security organization can make arrests in respect to any security breach. But we have agencies that are mandated by the Constitution to what? To take those victims or those found wanting to the courts for prosecutions. They don't have power to prosecute, but they have the power to arrest and investigate. Then hand over to those agencies who are empowered by the Constitution to prosecute. But what we find out is, you see most of these people who are in the offices try to use certain powers to do things, which is what is causing all this rancor. But the main objective or the act that give them the powers to do what they are doing are clearly spelled. What we need to have is what? Harmonization, coming together of these agencies to protect the average Nigerian on the street. Now, if you pick a scenario that you're driving your car on the road and then a policeman stops you and said, where are your particulars? Ordinarily, you might feel that's a function of road safety. You understand? But when somebody is driving and has a bomb in his car, you will still expect that, and I saw police there, and I saw road safety there. So the spirit of security agencies is to stop any breach, any security breach. They are supposed to work together, work in hand to protect the citizens. That is their primary responsibility. But what we have is each of the security agencies fighting to take glory or fighting to outmuscle their fellow, yes, instead of them working hand in hand. And I believe those are the areas that we are supposed to really look at and address it. Yes, sir. Not really breach. They need to work hand in hand. Because to secure an average citizen on the street, even the cyber crime you are talking about, the cyber crime is doing harm to a lot of Nigerians, even our image abroad. So if the military can arrest somebody under cyber crime, there's nothing wrong with it. But what you should do ordinarily is, after investigation, you hand them over to prosecuting agencies to do the rest. Now, I also observe something I don't know because of the slide, and when to do. Now, when you said the federal government should ensure that citizens are properly informed about a policy before it is being passed in the National Assembly, that's a very, very, very recommendation. If you are going to make any recommendation, it should be an actionable recommendation. What do I mean by that? Now, if you are talking about the security agencies, and you said the police, the army, the air force, the DSS are found wanting in a particular area, then, and it has to do with the act that establishes them, then you come to where you are making a recommendation. Then you are going to say the National Assembly should look into the act by mandating the Committee on National Security to review the act that establishes those agencies. So when this paper gets to the corridors of those in power, if you write that letter to the Senate President, you have made his work easier. They don't have time to read and start as trying to understand what you are saying. But when you make your recommendation actionable, the man will just pick his pen and just minute it to the relevant committees to act. But when you write a paper, say to the Senate President, and say the federal government should ensure that people are well, the man will just pass. The man will just pass. You are giving him time to start thinking who are the agency in charge of looking at informing citizens. Who are the... So you will just ignore that recommendation. But when you make it very clear, the National Assembly should ensure that the act that establishes the DSS is being reviewed through the Committee on National Security. You just mean to the chairman, the Committee on National Security. Then before you know it, you have set action into road. So sometimes when you are making presentations, if you come to the recommendation part, please try and make sure that you are very definite in making your recommendation. Now, lastly, let me not take much of your time. I look at the issue of food security. Now, the presentation of food security you have to look at the affordability of that food to the common man on the street. How does it affect? How does the common man have access to food? And what is the impact of that particular policy to making food readily available to citizens? Now, and that will now bring about the inflation rate. How does inflation affect or have impact negatively on availability of food or making food available for everybody? So when you are looking at food security and climate change, I think you have to go a little bit deeper. I think the MDAs will help in that aspect because they always releases information or data on food inflation and the number of poverty and what have. So you have to look down to that so that your report will look caged and very apt, because if you are making this kind of report, you have to make certain citations. As of 2015, as of December last year, as of January this year, there were a report from the MBS about food security, about the prices of food in the market, how does it affect common man, and what areas of intervention can the government come to make these things available. So it's going to make your report very, very easy. And then there's what we call evidence-informed policy making. Now, in course of the presentation, I had some people say the National Assembly should ensure that before any agency is created, there must be evidence that there is a loophole or a lacuna where that agency is coming to act. Now, if you look at the National Assembly is a house of politicians, and politicians go with interest. Now, if you are saying you want to write to the Senate President or the principal officers of the National Assembly, calling their attention to the urgent need to address issues of creating agencies that overlap their responsibility, then you are now bringing issue of let the agency come and present. What happens is that most at times we have, I think, 3 types of bill: those that come from the executive, and then there's those that come from the members of National Assembly. Now, when a member of National Assembly brings a bill to the floor, what he does is that to him he was already captured the interest he wants to present, and definitely he will go around to influence other members to support that bill. Now, if you are writing to counter that kind of a thing, because you are now asking the legislature to choose between his own personal interest or interest of his constituency that he brought to the floor with national interest. What is national interest? Let us not create agencies that will now have overlapping responsibilities. In that kind of situation, whatever paper you are writing must be able to address objectively the fears of overlapping responsibility and with proper citation. Some of the agencies, a lot of agencies were brought before the National Assembly and they were turned down due to the fact that they have overlapping responsibilities. But for you to do that effectively, you must be able to write objectively on the impact or the aftermath effect of that bill scaling through. That means you have to do a lot of analysis, impact analysis from the starting point to the implementation stage and the negative impact that will come after that bill or that act has been passed. So that when the senator or the National Assembly looks at that report, they will be convinced not to let such agencies pass, because it's not easy to make a legislator to just drop his interest. It's something, it might look very easy when you say it, but in practical terms, you must convince them beyond any reasonable doubt. Thank you very much.
I personally have also learned a lot from his comments, and I believe that it speaks to the spirit of this event. It's a capacity development event. You understand? With these few points that you just highlighted, I know that by the time we are doing another event like this, it will reflect. You know, a lot of the things that he has said are things that maybe we thought about, but this is a practical example of the benefits of incorporating those elements. So I want to say a very big thank you. We really do appreciate it. A round of applause for you. Thank you very much. So at this point, time is well fast spent. So I will invite our resource people to come and do the final closeouts.
Amongst us, and we've learned a lot. To all our presenters and all those that have contributed in one way or the other, we say a big thank you. Thank you and enjoy the rest of your day.